Hi, everyone. Welcome to our community webinar of the month. I will wait a few moments to wait for some people to trickle in, I should say. Hi, Lindsay. Hi, Kathy, Nancy, everyone. Today is a really special webinar for us. Our presenter for today shares the same name as myself. Mr. Joey Vitale is a man of many talents. He is the founder of Indie Law. He's a business coach, he's a speaker, and a very long time Dubsado supporter. So we're really grateful to have him on with us to share some legal gems on protecting your brand, and in his own words, getting legally legit. So this one's going to be packed with information on making sure you're protecting your brand and building that foundation to have hopefully a problem-free future with your business. So I will not take up too much time. I will go ahead and pass this off to Joey. And we have talked to you. We'll do a bit of Q&A at the end. But thank you all for being here, and special thanks to Joey for giving us your valuable time.
Well, thank you, Joey. And I'm really excited to dive in. I'm excited to get to know all of you. And I know that trademarks and legal stuff can not be the funnest thing to tune into, but I promise you, this will be the best legal training you've ever sat in on. Thank you, Patty. I'm excited to be hosting this. And like Joey said, we both share names. So just to make sure that the chat feature is working for everybody, please say thank you, Joey, in the chat, meaning the other Joey. Give him some props, and that way I'll be able to see some names come through and make sure that the chat is working for everybody. So welcome to today's training, all about how to protect your brand and get legally legit, aka the 3 big trademarks mistakes you need to avoid so you don't lose your entire brand overnight. Let's start here. You might be wondering, oh man, am I in the right place? What was I thinking signing up for or deciding to watch this legal training? Well, let's get clear and make sure that you're where you're supposed to be. You're in the right place if you've got a growing business and a big vision, but trademarks are honestly pretty confusing, and you're committed to protecting your brand against big risks. And very importantly, you want one less thing to keep you up at night. If you're still with me, sweet. So here's what you're going to learn with hanging out with us today. And just to make sure that my video isn't going over any of my text on the slides here, I'll get rid of my video. So here's what you're going to learn from hanging out with all of us today. First off, I'm going to deliver as much valuable education as I can in the next 30 to 45 minutes or so, and then we'll have time for questions. I promise you, this is going to be actionable and practical. I like to tell my clients, the students in my programs, that, look, I went to law school so that you don't have to. So I'm not going to be throwing the equivalent of a law school casebook at you, but you will have some great golden nuggets to walk away with. My law firm, Indie Law, has filed well over 500 trademarks, so you can be confident that my team and I really know this stuff. That being said, be open to learning something new, because trademarks are one of those weird areas of the law where a lot of it actually goes against common sense and what you think it does. So be ready to have your head explosion emoji keyboard enacted, and make sure that you're closing out other tabs, silence your phone, get ready to take notes. Yes, I said that this would be an unusually helpful and entertaining legal training, but in order for this to be helpful for you, you need to be paying attention. So do what you got to do to get rid of those other distractions. And we're going to be talking a lot about trademarks, but before we do that, let me talk about this first. I've got an action taker bonus for all of you. So I do have these deeper dive resources that I'd be happy to share with all of you. And unfortunately, we don't have time today to get into all of what you need to know about trademarks. So I've got 2 high-level bonus resources that I'm going to share with all of you at no cost if you stick with me to the end. So at the end of this training, I'm going to share a link for you to access those resources and also give me and Dubsado some feedback. And let's start here. I get it. I know legal stuff can be confusing. My question for you, give me a 1 if this is true for you in the chat. Does legal talk make you want to put your head in the sand? Give me a 1 if just looking at these legal words makes you want to look away from the screen. If that's you, well, you're not alone. Actually, most even of my lawyer friends don't actually like speaking in legal talk. So thank you, Melanie Oates, for the 1. Patty says 1. Stacy, Nancy, thank you guys for the engagement. So here's my promise to you all. Someone says, yeah, a little bit. Here's what I want to do. I'm going to keep legalese to an absolute minimum. And I don't know about you, but just by whiting those words and phrases out, I feel a little bit lighter. And so I hope that we can now say, okay, if we're not going to get super legal jargony, maybe we can all lean into this more and figure out what's going on when it comes to trademarks. And I want to do a quick informal poll. How would you rate your knowledge of trademarks? Give me a chat in the chat. Give me a number 1 if you feel like you are a trademark ninja. Give me a 2 if you kind of understand what trademarks are. You feel like you have a kind of good understanding, and give me a 3 if you feel like you're absolutely clueless when it comes to trademarks. 1 is a ninja, 2 is somewhat knowledgeable, and 3 means that you're totally new to this. All right, I'm getting a mix of some 2s and some 3s, so another good indication that you're in the right place here. Before we talk about trademarks, I want to walk you through this really fancy graphic that I made. So at the end of the day, your business needs 4 things for it to be successful and thriving. First, you need a brand. You need something that is distinctive in the marketplace, something that separates you from all of your competitors. I like to think about it this way. When you walk down that cereal aisle version of your industry, what is it that makes people choose like your box of cereal for whatever it is that you do over the competitors? And if you don't have a strong brand, well, then you're really just more of a commodity. You're like that bottom shelf cereal that's not even in a box. It's just in a bag. It's like the wheat O's or whatever. And because your brand isn't really distinctive, well, a lot of times that's where you fall in the traps of having to compete on price, because you haven't built a distinctive brand over time that is shows people that it's not just you providing your services, but you providing your services in a unique way that is uniquely valuable to your products or services to your customers and clients. So that's number 1. Number 2 is separation. I 100% believe that your value is not defined by however good or bad your business is doing right now. And it's really important as a business owner to keep that separation mindset in place, that no matter where you're at in business, you can't let that affect you personally. The third box here is relationships. And in business, we have relationships everywhere, from customers and clients to team, to people who are visiting our website, to people who are following us on social media. And ideally, we have to manage and maintain all of those relationships. And then fourth and finally, we've got content. This is the stuff that we put out in there. We put out into the world, and we hope and expect that when people see us, they find out about us, they become leads, they become clients, they become raving fans. Cool. So this might seem very introductory, but the reason why I want to start here is because a lot of times people say, okay, Joey, let's talk about the legal side of business. What are all of these terms, these things that we need to be thinking about when it comes to the legal side of the business? But the truth is, there's no legal side to your business. Really, there's just a legal layering that happens to this box. And really, there's just a legal counterpart to each one of these 4 boxes. So trademarks protect your brand. That's your business name, logo, slogan, those distinctive things about your business that make you different from competitors. And we can talk about separation all day, but if you don't have an LLC or a corporation, if you're fancy, then that means you're a sole proprietorship. And legally and technically speaking, that means that you are your business. And it's really hard to have that separation mindset in place when legally that's not the case. When it comes to relationships, well, we have all sorts of contracts that come into play for that. That could be contracts that you have inside of Dubsado, to terms of use on your website, to whatever. And then finally, there's content, which is protected by copyrights. And that's a great nugget to walk away with too, because a lot of times people get confused about trademarks versus copyrights. Feel free to take a screenshot of this, because this is a really helpful view of that distinction between the two. Trademarks protect your brand, whereas copyrights protect your content. I hope that that was helpful for all of you. And it leads me to something that is a little bit more serious. Not really. We're not really into the serious part of the training yet. Let me know in the chat, who is your favorite Marvel superhero? I was an okay fan of Marvel before COVID started. And then ever since I had to stay in my apartment, I think I've seen every single movie and show that they've created. And there are a ton of superheroes to choose from. I know I'm not the only one who's been watching this stuff. I got to say, personally, I've become a Spider-Man guy, especially since the last movie came out. Patty, yeah, Tony Stark is the man too. But I was thinking about Marvel the other day, and I was thinking about this training, and I thought this could be a fun, kind of useful way of introducing everything. Imagine that your favorite actor, whether Marvel or not, gave your business a shout out on social media. Just imagine how much that visibility from some famous person who's drawing eyes to your business would change your business. Like, you could easily get 3 to 4 to 10x new leads overnight because this person tagged you on Twitter or whatever, right? So let's have a friendly competition where let's just imagine that everybody on this training got a shout out from a celebrity, meaning that now we're all getting tons of leads and eyes on our business. Let's have a friendly competition for $50,000 to the business owner who's most prepared for the rapid growth that would come from that type of visibility. Well, if we put ourselves in this situation, you're probably going to fall in one or two camps. The first type of person is, I call her Taylor. She's the swamped entrepreneur. And if she got super visible like this, this would be true. She's busy with all the other parts of her business, and she just hasn't thought to make trademarks a priority yet. She's now realizing that she's duct taped together a brand protection strategy, in quotes, up to this point, and doesn't feel very safe. She's never secured any trademark rights before and is just crossing her fingers that her brand isn't already taken. And she's worried about copycats stealing her stuff, so she stresses out about others profiting from her work. So that was Taylor. Let's contrast that with Lindsay, the Legally Legit CEO. You see, Lindsay has proactively applied for trademarks to secure her business name, her logo, slogan, and other big brand assets. So when she gets a lot of visibility like this, she doesn't freak out, but instead she just reviews her enforcement plans and updates her team on the great news. She can go to bed easy at night knowing that her brand isn't at risk of being stolen or taken away from her. And she's ready to handle copycat situations objectively and competently without being seen as either a bully or a doormat. Now, my question for all of you is, who would you be if your business suddenly went viral? Would you be a Taylor or a Lindsay, the swamped entrepreneur or the legally legit CEO? Let me know in the chat and give me a 1 or a 2. And if you feel like, oh, maybe a 1.5, I challenge you to pick one. Which resonates more, a 1 or a 2? I'll let a couple trickle in here. Stacy says Taylor. Taylor. one. Okay. I am saying all of this because if we're being honest, most entrepreneurs can relate to Taylor here. And I can say this because I've learned that as a lawyer, there's this client confidentiality that we owe to all of our clients. So business owners and people tell me things about their businesses that they don't tell their business besties. The hard stuff that's going on behind the scenes, everything that's duct taped together. And so I have a unique viewpoint on the insides and the ugly insides of most businesses. So I just want to let you know that if you feel like an option one, don't feel bad. I mean, we're going to try and fix that in today's training, but you're in really good company and you're not crazy. By the way, welcome to Indie Law, which is my law firm. We help Taylors become Lindseys. And we're not really your average law firm. We don't like to argue just to argue, which is part of the reason why we focus on trademarks. We help people avoid the courtroom in the first place. We absolutely love entrepreneurs and working with people like you, and we focus just on trademarks. It's all we do, and it's our jam. That's one of our slogans at Indie Law. You can see some headshots of my team there. And you might be wondering, why does Indie Law just do trademarks? Well, it comes back to this. We as business owners don't know what we don't know. And one of the things that I've learned as an attorney in this space now for almost 5 years is that not all legal problems are created equal. I found, we used to do a bunch of stuff, not just trademarks, but we found that our clients were most likely to get blindsided by trademark problems specifically. And so after years of being a general business law firm, doing things like contracts, entity formations, and all kinds of IP or intellectual property work, we finally had our big light bulb moment. And we rebranded everything to become a trademark-only law firm. You can see in that screenshot there that one of our slogans is we put the rad in trademarks. I'll explain more about what that means in a bit. But when we decided to make this change, we quickly started getting better and more reviews from our clients. I love it now when our clients send us these trademark selfies of them getting their registrations in the mail, but I'm getting ahead of myself. Most business owners are making 3 big mistakes that put their brand in danger. And so we're going to be diving into those mistakes in this training so that you can avoid them. Here's mistake number 1. The mistake is I don't need a trademark because I already have a fill in the blank. Maybe that's you already have an LLC with that name or a website domain or a social media handle. I hear this all the freaking time. So let's talk about why this is a mistake. What exactly is a trademark? Well, I could tell you that it could be a business name, a logo, a slogan, a course, a podcast, a product line, a signature method. But that doesn't really tell us what it is. And there is like a legal definition of what a trademark is, but I found that it's not really that helpful to go through. So let's start here, because a lot of times, if I were to tell you that Nike or McDonald's or Target, that they own trademarks to those names, that makes sense, right? Of course, Nike owns Nike and what else? But here's where it gets a little interesting. Let me know in the chat, and this is not a trick question. Who do you think owns Hakuna Matata? At least one brave person. Let me know in the chat. Again, this is not a tricky, super easy question. If you think you know it, let me know in the chat. Yep. Thank you guys. Stacy and Patty say Disney. I'm seeing some other Disney come in. You guys are correct. So if I was able to pull one of you, if I was able to kind of pull, reach my hand into the screen, have you sit next to me and say, hey, what was going on in your mind when you said, Disney for Hakuna Matata? Well, you might have told me something like this. Well, I think of that Timon and Pumbaa song, which is from the movie Lion King, which is owned by Disney. That is a trademark at work. That thought process is what makes it a trademark. And we trademark lawyers, we call this source identification, but it's any time that you observe or see a word or a phrase, it makes you think of one brand in particular. That is a trademark. Melanie says, yep, that's what my brain did. Love it. So now that we have a better understanding of what a trademark is, how do you protect a trademark? And the first question here is really, do you already have a trademark? And I'm sure a lot of you would say, Joey, no, I don't have a trademark, which is why I'm watching this training. You would be surprised. So let me walk through this because this is a little ninja, but I promise you, you can all get this. So I like to use this metaphor of a house and a fence. So let's say that you build this house. So you've got this house, but it's not really protected until you put a fence around it. That's kind of what's happening when it comes to trademarks, because there are actually multiple different layers of trademark protections here in the United States. And according to one of those levels, just by being in business, you automatically have your house. That's right. Just by being in business, just by having a brand where people can buy from, that gives you a certain layer of trademark rights where to an extent you are already trademarked. The problem is those automatic, they're called common law trademark rights. You might technically have them, but they're super weak. What you really want is you want a fence around it. And so you might have seen these little symbols before or after things. As soon as I became a trademark lawyer, I could never go to a sports game the same way ever again because I now see these symbols everywhere. But I want to talk about the difference between these symbols, because that TM symbol, all that means is that someone has common law automatic trademark rights, that they've got their house, that they might not have taken any action on or anything or filed any paperwork or paid any money, but technically they do have trademark rights. But those automatic trademark rights are limited to a geographic region. So back in the day, pre-internet, it might have been fine for a brand to rely on its automatic trademark rights if it didn't want other competitors in the region. But if you want to beef up your rights to nationwide protection, then you need a federal trademark. You need that fence. And you can only use that circle R symbol for when you have a registered trademark. Okay, this is usually the head explosion emoji part of this training, because so many people don't realize that you can start using that TM symbol today for free without having to file or pay for anything, because that TM symbol just is a sign for automatic rights. So if you haven't yet started adding that TM symbol to your branding, to your website, things like that, I really recommend it. Like, yes, practically speaking, you don't have those strong registration rights, but it can be a really strong deterrent, because when others see that, they might not know the difference. But we'll talk more about the trademark registration process and why that's important. But it's really, really great as a business owner to know that there's this free step available of just using that TM symbol. So it's not really about getting a trademark. It's really about claiming a trademark you already have and are using. I know Melanie says, wow, I never knew that. I know I didn't. And most business owners don't know this difference either. But again, it's a really, really great trick that you can pull just to add that TM symbol to your brand. So poll number 2, are you currently making use of that TM symbol in your business and branding? Give me a 1 if you've used this stuff before, if you use that TM symbol, and give me a 2 if you haven't, but you will after this training. Again, that's a 1 if you have used this before, and a 2 if you haven't, but you will. Awesome. Thanks, Danielle. She gives us a 2. Stacy, 2. Patty already knew this. Great. Or she's been using it at least. Awesome. Again, this is a great takeaway for everyone here to start using that TM symbol. So now let's talk about why trademarks. And here are just a few reasons why you should consider actually registering your trademarks, getting that circle R, because you don't have strong proof of ownership without a registration. When you apply for and get a federal trademark registration, it's almost like getting a birth certificate for your brand. Like actually having really strong proof that you own what you say you own. It can be really, really difficult and expensive to defend and enforce your rights without it. And rebranding becomes increasingly expensive as your business grows. So it's best to just proactively make sure you can get that circle R while you're still at a newer emerging stage in your business. And keep in mind, the average trademark dispute can easily cost over $200,000, which is a lot of money for a small business. So take that into account. Plus, they're just a sign that your brand is really legally legit. It can really make a difference when clients see that circle R. I 100% believe that your success is inevitable, but that means that problems are also inevitable. And without trademarks, you're just one cease and desist letter away from losing your entire brand. I'll say this one more time because it bears repeating. A trademark dispute can easily cost over $200,000. So let's focus on solving this big problem of brand protection first. Okay, now we're at mistake number 2, which is I'll wait to handle trademark later once my business gets bigger. And I just want to say before I dive into it that I understand why people are making this mistake. Because when it comes to growing your business, you've got so many business consultants and coaches and business besties telling you what you should do, what you should invest in your business, and what you should kind of hold off on and wait until your business gets to a certain level before you make the investment. And it can become really tricky as business owners to know what to invest in, what not to. But I want to highlight this. We have a pretty big problem in the legal arena. And I'm going to ask you to do something kind of crazy. Imagine if all entrepreneurs were jugglers in a field. Like every single entrepreneur got into some big field, and like I live in Chicago, so they just cram everybody in. Social distancing isn't a thing. Everyone's packed. And on the count of 3, everyone starts juggling. And what they're juggling are the different little brand elements in their business. So if your business has a business name, a logo, and a slogan, that's 3 things that you're juggling. Take a moment to think about what this would actually look like. Like craziness, right? It would look something like this. Just total chaos in the air. I'm asking you to think and visualize this because this picture is just as hard hitting, even though it's probably a little less boring than what I'm about to show you, which is a table and chart from the trademark office. So stick with me. This is a chart that comes directly from the trademark office that shows the number of trademark registration certificates issued every year from 1998 to 2018. And as you can see, with just a couple of exceptions, every year that number has grown. And if you're having trouble seeing it on the screen, that's almost 300,000 registrations in 2018 alone. Now, this is the big number, but my team and I, we looked at this and we were like, oh, this isn't even telling us the whole story, because we know that there are a lot of applications that get sent that actually get rejected or denied, and people don't get their registration. So we did some more digging because we wanted to figure out, okay, in 2018, how many applications were submitted? And we found the answer. Well over 500,000. And if you look at these numbers, it's showing you that over half of the applications didn't get accepted and become trademark registrations. This is a lot of paperwork, a lot of trademarks. I say this because we are literally running out of trademarks. We're running out of things like business names. And I say this with all of the love and care that I can in the world. But if I didn't say this, I wouldn't be doing my job as a lawyer. there's a really strong chance that right now you're accidentally infringing on someone else. And that's definitely not a good place to be building your business from. And so before we can talk about protecting your business, we have to have a serious conversation about availability and what that means. And that's why trademarks are a cost of doing business. Without securing your own brand with the trademark registration, you're taking a huge risk of infringing on another brand or at least being accused of it. Which brings us to the third and final mistake. I did a trademark search and I'm fine. No one else has it. There's this question that we have to explore of, is your trademark available? And if you're like most business owners, you do some things before you just commit to a name, right? You hop on Google, you try and grab the domain name, maybe you get the social media handles, maybe you form that LLC, and those are all great steps. We want to make sure that this name is available, right? But that's not everything. You also have to go to the trademark database here in the US. And one of the bonuses that I have for you guys that I mentioned earlier, it goes more into detail on how to find and use this database. But if you've been here before, you know that this is a free database, which is cool. It looks like a 1990s version of Google, but it works. You can type in words or phrases and it'll tell you, a results page will pop up and let you know what it sees. And I want to do a quick poll here. Have you ever done a trademark search before it's called uspto.gov is the website. Give me a Y for yes or an N for no. Just let me know in the chat. I'm always curious who's learned this stuff so far and who hasn't. Sarah says no. Okay. Melanie says yes. Patty says no. Okay. So let's talk about, and by the way, again, like I said, you guys, I have a bonus that I'll give you that walks you through how to find and use that database. Super, super helpful. But that's still not everything. So we've done the looking before we leap. We've done the Google searching and everything. We've searched the database, but now we have to think about this thing that I call the likelihood of confusion trap. What I've put here are a list of different trademark applications that were filed. And what happened in each one of these instances is the trademark application got denied, not because there was another trademark that was the exact same, but it was similar enough. And the trademark office said, hey, this could confuse customers, so we're not going to allow both of these to exist. And these are frustrating because if you search FAMPRENEUR and nothing shows up, so then you apply for a FAMILYPRENEUR, you'll be pretty caught off guard when they says, oh, FAMPRENEUR exists. And this is one of the shortcomings of that search database, is it doesn't do a really great job of showing us all of the kind of confusingly similar but not the same trademarks. This isn't like buying a domain name where if it's slightly different, you're okay. And this might seem frustrating. You might be frustrated reading this list like, man, these like uphill battles that legally we have to work through to be okay. I totally understand that frustration. And I also want to show you why it's like this, because the trademark office isn't just trying to be jerks about all of it. I want to highlight this last example. So a lot of you probably know that there's this big brand out there called Blue Apron. And Blue Apron is this food delivery box service. I know there's a lot more of them now than there were years ago, but they were one of the first ones on the scene. And they own the trademark for Blue Apron. And recently, another brand filed for a trademark for Green Apron, and it got denied. And the trademark office said, these are two similar trademarks. And it kind of makes sense, right? Like customers of Blue Apron might see Green Apron and think, oh, is this like Blue Apron's all veggie box? Is this their like recycling, like super recycling materials version of what they've got going? It could be connected and it could confuse people, right? I love this example because the company that actually tried to trademark Green Apron was Starbucks. So I love this example because number one, it explains kind of why the trademark office is more of a stickler about these things because they really want to avoid customer confusion in the marketplace. But I also love this example because even big businesses get rejected. And in this case, Blue Apron won over Starbucks. So it's always helpful to think about why our legal system is set up the way that it is. So, okay, we've talked about that likelihood of confusion trap. One more thing here is you need to take action after you've searched. Again, going back to the number and frequency of applications being filed. You have to really, really be mindful if you do like a big availability search that you get your application submitted pretty quickly after you complete that search. Some of the biggest horror stories I can tell you from our law firm is when clients sign up with us, we do some level of a search. For whatever reason, we wait a while to get the application filed. And then by the time that we actually are ready to move forward, someone beat them to the punch. Someone got a similar filing in before our client did. And now it's a lot more expensive to either dispute that other trademark, or more common is just to rebrand because it's really expensive to dispute trademarks. Okay, I know that was a lot. So let's do a quick recap of these 3 mistakes. Mistake number 1 is I don't need a trademark because I already have a fill in the blank. But the truth there is that you don't own your brand without trademarks, and that circle R, that registration, is proof. Mistake number 2 is I'll wait to handle trademarks later once my business gets bigger. But the truth is that trademarks help ensure that your brand is even available. And mistake number 3 is I did a search and I'm fine. No one else has this. But the truth is that comprehensive searches are tricky to do and they expire immediately. I encourage and invite all of you, especially if you're watching this over like a desktop, go ahead and screenshot this or from your phone. This is a really great 1-slide summary takeaway of this entire training. And I'm a huge minimalist. I love simplifying things as much as I can. So one more summary slide here. Number 1, if you're growing, you need trademarks. Number 2, you need to make sure it's available. And number 3, you need to take action after searching. So the big takeaway here is without trademark registrations in place, you're putting your business at risk of losing its brand recognition or letting your competition steal from you without recourse. So it's critical to call dibs as soon as possible. That circle R can be yours, giving you confidence that you know that you own your brand. You can be proactive on the legal side instead of reactive. You can actually understand the process and significance of brand protection and all this legal stuff. You can call legal dibs on it so that others can't take your special sauce. And you can use your website domains, social media accounts, and business names without fear of getting slapped with a cease and desist letter. Again, keep in mind that we are literally running out of business names at the trademark office. And because of the way that our laws work, we got to be careful of that likelihood of confusion trap. The goal here, again, is for everyone to be Lindsay, to proactively apply for trademarks so that you don't freak out, you go to bed easy, and you handle those inevitable copycat situations objectively and confidently. Okay, real quick, and I think this is the final poll. What action steps will you take now that you've watched this webinar? Here's what I want you to do. Give me a 1 in the chat if you'd like to speak to me and my legal team, or if you're committed to reaching out to some lawyer about this. Give me a 1 if that's the case. Give me a 2 if you're just going to look into some more resources on your own, see what you can do here. And give me a number 3, and this is okay, if you've watched this training and you just feel okay and you're not going to take action after this. And I'm giving you that option because as much as I recommend this stuff, the last thing I recommend is indecision as a business owner. So ideally, you decide to move forward with this, or you say, this is all great, I'm not going to make this a priority, I'm just going to move on and focus on other stuff. So again, 1 is reach out to a lawyer or a law firm. 2 is do your own research and figure out next steps. 3 is just kind of say heck no to this for now and maybe revisit in a couple of months. Stacy Robinson, real quick, I'll answer this question because this does apply. Stacy says, do you serve Canadian businesses? Yes, we do, but we're limited to providing US trademark protections. So no matter where you are in the world, if you have a customer base in the United States, then we highly recommend getting your brand protected in the United States. And it's more and more common for people overseas, not just to have US customer and client bases, but for most of their customers and clients or social media followers to be based in the United States. So if that's true, then you want to really be prioritizing US protections over others, regardless of where you are. Hope that was helpful, Stacy. So earlier I referenced this, just a little bit more about indie law. Again, one of our slogans is that we put the RAD in trademarks. That's actually like our signature strategy. So the RAD is short for Ready, Aim, Done. First, we review the trademark and compare it to others for red flags. Then we strategically prepare the application for successful registration. And finally, we submit the application and do all the heavy lifting for you. Like I said, we do all the heavy lifting, so you relax. We'll take care of you throughout the process. And I know this is a tech-savvy bunch, so just so you know, everything is flat fees with us, so you never have to worry about the hourly rate of a typical law firm. If you're ready to book a free brand protection call or just get resources, I'm going to drop something in the chat now. It may or may not work with, I forget how if things are hyperlinked here, but just go to indielaw.com/bonus. And that'll take you to some resources you can get. And then from there, you can book a call with our team. Speaking of the bonus, here we go again. Like I said earlier, we don't have time today to dive into everything, but I've got 2 bonus resources for you. You can just go to indielaw.com/bonus. Oh, it's www.indielaw.com/bonus. There we go. So I'm going to now start to shift to answering some questions. Feel free to, let's go ahead and use that Q&A feature where we can. And then Danielle asked this question about copyright as well. Danielle says, do you do copyright for materials too? I.e., I have a program I created that I want protected. Danielle, we do not, but I have some great referrals on that I can send you to. The short answer is you'll want to be thinking not just about the copyright registration process, but also taking a strong look at your contracts so that your contracts have language in there related to copyright that is aligned with your actual registrations. It's good to have both of those there. Okay. So I see 2 questions in Q&A, and I'm just going to circle back and forth. And to my other man, Joey, who's helping out with this, Joey, feel free to let me know if there's any other questions or anything.
Will do. Thank you.
So Patty says, I have 2 questions. First, my company name has my personal name in it. Will I hit a brick wall because of that? And then number 2, my services are global and I have plans on living overseas partially at some point. I know a registered trademark is federal in the United States. My question is this: regardless of where I physically live, is my brand protected with a registered trademark based on the country of origin where the business is registered? Great 2 questions, Patty. In terms of the first one, where your company name has your personal name in it, the short answer is no, you will not hit a brick wall because of that. I will say that usually businesses that have their company name as their personal name, that might not be the primary brand element that you want to get trademarked first. Meaning there might be a slogan or a name of a podcast or course or something that is more distinctive, that's less tied to your name. And there might be a bigger risk there of someone using something similar. That being said, you can totally apply for a trademark with your name on it. My team and my clients, we help people do that all the time, and that won't be an issue. Two, great question about going overseas. The main thing to keep in mind here is that trademarks, the point of trademarks are actually to protect customers, not so much to protect clients. They exist to prevent confusion in the marketplace. And so from that standpoint, trademarks aren't really about your business and where it's based. It's more about where your customers are located and where they're seeing your brand and working with your brand. So your question is this: regardless of where I physically live, is my brand protected with a registered trademark based on the country of origin? So it doesn't have to be connected to the country of origin whatsoever. And we have a lot of businesses that are, people who are living in and based in another country, or people who just travel a lot and spend most of their time out of the US. Whatever it is, it still might make the most sense for you to prioritize trademark protections in the United States, because that's where your customers are based. Hope that that's helpful. And then Melanie asks, if we have DBAs, does each DBA need a trademark, or is the main entity all that needs the trademark? Really great question, Melanie. Keep in mind that Hakuna Matata effect of trademarks, and that really the naming protections that you get with trademarks are less about what you filed with your state in terms of your business name and DBAs, and it's more about, okay, what is your customer really seeing? And yes, ideally, you will want to protect all of your trademarks. And if those DBAs are all different things that clients and customers see, those all might be things that eventually you file trademark applications for. That brings us up to a really good question of what should you trademark first? And that is something that I think is covered in the bonuses that I send you. If not, you can reach out. We have some resources there that are really helpful with helping service providers get a sense of, okay, if I'm a typical online business service provider and I have potentially a lot of trademarks in my brand, from my business name to my logo to my slogan to a podcast, course, product line, all that stuff, what should I do first? We can help you kind of prioritize that list so you have a better sense of where to start. Okay, so it looks like that was all of the questions. Joey, anything more from me?
Nothing in particular. I just wanted to say a quick thank you once again. Honestly, this is such an engaging and valuable description. The way that you're describing everything is hopefully going to be helpful and easy for people to understand. Even myself, I just work for Dubsado, but it's quite a lot of stuff to get to know, and it's something that I hope a lot of our other business owners in our community can really sort of sink into and take seriously. So thank you. This was super engaging, and I have no doubt that this will really help people just understand what's important in terms of protecting their business. So thank you so much for your time, Joey. I really can't say it enough. We're really grateful for you, and we're always going to be rooting for you. So I appreciate your time. Really.
Well, likewise, Dubsado is the best. Its users are the best. Thank you all for having me. It's really an honor and a joy to have to be here. And with that all being said, I guess, Joey, we can close out here.
Yeah, we'll go ahead and wrap up. Again, thank you again, Joey Vitale, Indie Law, and thank you for everyone that's joining us. I have no doubt this is going to get a lot of recorded views as well. So thank you once again, and I hope you all have a good rest of your week. Bye now.